Good afternoon, everyone. My name is Teresa Monjovi. I'm a partner at Post and Shell, and I'm co-presenting with my partner, Angela Sanders, and we're here to ask you whether you're ready for round two of the pandemic. Some may argue that we're on round three, four, and five, but our goal today is to provide you with updates on COVID-19. There's been a lot of information that has occurred within the last month since the last seminar of our colleague Andrea Kirschenbaum, and we're hoping to give you a preview of what to expect for what we expect to be another interesting fall. Again, my name's Teresa Monjovi, and Angela Sanders and I are located in the Lancaster office. We primarily focus on employment law and business counseling. We're going to go over a fair amount of content today, but we want you to be able to ask questions. So obviously, feel free to put information in the chat. If we don't answer it, we're happy to have discussions with anyone offline after this webinar. So as many of you may know, President Biden issued a 6-point plan on September 9th, where he outlined various issues that he is going to be mandating across the United States. We're going to go over the 6-point plan with the recognition that President Biden's announcement came with it an absence of clarity on a lot of points. And we're going to give you some other guidance. At this point, we do not have all of the regulations and anticipated emergency temporary standards have not yet been issued by OSHA, but we're going to give you some guidance so that you know what you should be thinking about. So President Biden's 6 points really dealt with the most important issue for employers is the increased vaccination 6-point plan. So one of the elements is that there are going to be requirements for all nursing home workers who treat patients. All executive branch federal employees must be vaccinated pursuant to an executive order, which is now in place. All federal contractor employees are to be vaccinated, and we'll talk about more of that later in this presentation. And perhaps what is having most of an impact is his requirement that employers with 100 or more employees will be required to have employees be vaccinated or provide proof of weekly negative tests if they're going to continue working. And also a requirement that as employers with 100 or more employees will be having to provide paid time off to get vaxxed and recover from vaccinations. There'll also be, we anticipate some guidance on large entertainment venues that will be encouraged to require vaccines or negative tests for entry. I'm already seeing that, as I'm sure all of you are, in a number of the entertainment venues. The second point of Biden's 6-point plan is to protect the vaccinated. Authorization and distribution of booster shots. I think, as we know, the Pfizer vaccine boosters have been authorized by the FDA for certain groups, for certain high-risk groups. We're still waiting that to be expanded to everyone and also waiting for the Moderna booster shots to be authorized. So the recommendation is that a single booster shot dose would be administered 6 months after the completion of the primary series. And we have bullets in front of you that show the categories of people that are currently eligible for their Pfizer booster shots. The other element of Biden's plan was to keep kids safe and schools open. So obviously, I think we've learned that having remote school was not a large success for the education of most of our children. And one of the objectives is to try and keep kids in school. Vaccinations are encouraged for kids 12 and older, and any child under 12, anyone who lives with a child is recommended to be vaccinated. In schools, all educators in federal paid programs, Head Start programs must be vaccinated. And the governors are being encouraged by President Biden to require vaccination for teachers and staff. The Department of Education has been instructed to take legal action against states that are undermining protections that local schools have ordered, and we're already seeing lawsuits out of that, which is not highly relevant to employers, but another backdrop for the response to Biden's 6-point plan.
Some of the other initiatives that are included in the plan are ramping up of testing and masking. I'm sure that you've all heard in the news under both President Trump and now President Biden, the use of the Defense Production Act, which is a law that allows additional resources to go towards creating and production. And so that is being used right now to get more testing out in the community and to really get it accessible to people. Pharmacies, having free testing at pharmacies, having rapid tests, and having tests that people can do at home. We're seeing a renewed emphasis again on masking. I don't think this is news to anyone, but masking required on federal lands, on airlines, and increased enforcement authority for the TSA if people do not follow the rules. The fifth point is to protect economic recovery. There is continuing loan programs available, particularly to boost small business. I know that we've had multiple rounds of funding at this point with PPP and then funding through the American Rescue Plan. There are still loans available if you're in a small business and you've been really impacted by the pandemic. There's still opportunities available to take out loans on favorable terms. And then last is to continue to improve care. One of the initiatives is to create response teams that have been traveling throughout the country to highly hit areas and to use military resources to provide and enhance care. I'm sure some of you saw in the news over the past few months that states like Texas were getting hit to the point where their legislators and governor were asking, please come to Texas and help us because we're out of beds. And a renewed emphasis on looking at different treatment methods, and in particular, antibody treatments as something that could be more widely accessible to help when people have contracted COVID. So that's a general overview of the plan. We know there's a lot of pieces there that are not employer directed, but we're going to from here forward kind of focus more on what are the things that you need to be looking at as a business and as an employer.
One of the first questions we started getting from people on September 10th is, do I have to follow all of this now? And the answer is, for the most part, no. Unless you're in the healthcare industry or unless you are a federal contractor, we're still awaiting guidance from President Biden and actually from OSHA, who will be supposedly issuing what they call an emergency temporary standard, or an ETS. And President Biden said it would be soon. I think we're at our second week now. So until that ETS is issued, the 100 plus mandate for the bulk of employers is not a requirement under federal law. However, we're getting a lot of questions from people about what should we be expecting. We're trying to think about what types of programs. So we're going to be going over some of the emergency temporary standards that are already in place, because we believe they may be some indication of what the actual emergency temporary standard from OSHA will look like for the 100 plus employers. So let's start with federal contractors. If you are a federal contractor, you have some new things to be thinking about. Executive order was issued on September 9, 2021. That is different than Biden's 6-point plan, which was a plan. An executive order is an order that must immediately be followed. So this is currently in place. This is for federal contractors. How do you know if you're a federal contractor? Well, it applies to new contracts, new solicitations for the procurement of a contract or instrument for services covered by the Services Contract Act, for concessions, or anything entered into with the federal government in connection with federal property or lands. To be very clear, and I've had a lot of questions from that, particularly from municipalities, the order does not apply to grants, contracts, or instruments with Indian tribes. Contracts or subcontracts whose value is equal to or less than a threshold that is laid out in the federal contractor law. Employees who perform work outside the United States, or most importantly, subcontractors if you're solely provisioning products. So subcontractors provisioning products do not have to follow this executive order. What does the order actually provide? Well, we have guidance that has been issued by the Safer Federal Workforce Task Force. We have an executive order again issued September 24, 2021. What it basically does is it requires vaccinations for employees unless there is a disability or religious exemption, which we'll talk about in much greater detail. There's a requirement of, not a surprise, masking and physical distancing by both employees and visitors. And you must designate a person to coordinate your COVID-19 safety efforts at the workplace. For those of you in Pennsylvania, you recall under Governor Wolf's order, last year there was a requirement similar to that, but you have to have a safety person who's in charge of all of this if you're a federal contractor subject to this executive order. The first point of the order, vaccination. Employees must be fully vaccinated by December 8, 2021. They gave you 75 days from the issuance of the order. Fully vaccinated does not mean the first dose. It means 2 weeks after the final dose. So you need to have your final shot by November 24, 2021 if you're going to meet the deadline. Even employees who previously had COVID have to be vaccinated. As before, there are requirements for accommodations due to disability and religious beliefs that we'll talk about in greater detail. Agencies do have the ability to permit an emergency exception to allow employees to work prior to being fully vaccinated, but employees must be fully vaccinated within 60 days of beginning work on a contract, and the contractor is responsible for ensuring all masking requirements. Locations of workplace. This is another kind of sticky issue. So the questions are, does it depend on where my workplace is? Requirements will apply to all contractor workplace locations. If an employee is likely to be present working on the contract, it applies to outdoors. It even applies to remote workers who are working on covered contracts from home, which I find to be very interesting. However, graciously, our federal government has said we don't have to make people working from home mask or social distance. So maybe a little bit of common sense there. It can also include other areas of a website, of a work site. This would really be a situation where you can demarcate which staff members are working on contracts versus which are not, and that there's not going to be an interaction, which I would presume is difficult for the bulk of people. Questions are, how do we know if this applies based on our contract date? And the magic date that we have to remember is October 15, 2021. Anything awarded prior to October 15, the executive order requirements apply only when an option is exercised or an extension is made of that contract. If there were solicitations issued prior to October 15th and the contract was awarded prior to November 14th, agency is strongly encouraging contractors to include the executive order requirements in the contract. And obviously, if it was the solicitation and contracts are issued or executed after October 15th, all of these requirements must be included in the contract. One other key element, and although I know some of you are listening to me saying, I'm not a federal contractor, I don't have to pay attention to this, and this is accurate, except there are some clues based on some of these interpretations that are likely to be applicable in the ETS that is ultimately issued by OSHA for the 100+ employers. And one of the questions we've been hearing is, what is proof of vaccination? Is it okay that I just get people to affirm and sign and say that they were vaccinated? And under these rules, the answer is no. It has to be a record of immunization from a healthcare provider or pharmacy, the CDC card, medical records, immunization records from the public health or state system, or some other official documentation verifying that someone was vaccinated, the name, the date of administration, who administered it. That is what we are going to accept as proof of vaccination, which we anticipate may be carried through in the ETS, but we'll see. Non-covered contracts, they're encouraging people to incorporate these requirements. You're not required to, however, agencies will have the discretion to incorporate requirements into contracts, even if they're not covered by the president's executive order. And before we get into our next, I know there's, just to make an announcement, there is a question about, are we going to give you copies of our slides? And are we going to provide a recording? And the answer is yes, you will receive both at the conclusion. So if we bore you for part of it, you can come back and listen again.
All right, so healthcare employers. If you're on the line and you're a healthcare employer, you know that you've sort of been bombarded greater than any other type of employer with existing requirements and the fear of what may be coming. Healthcare employers are also in a little bit of a waiting pattern. Right now, we do have an existing OSHA emergency temporary standard that deals with certain aspects of what has to be happening as a healthcare employer. But in terms of vaccine mandation, we have a signal from the president outlined in his plan that it is coming. If you recall, when the president gave his press conference, he only mentioned nursing homes, and there was initially some reaction to that, thinking, well, does that really make sense? And then subsequently, almost immediately after the press conference, the Center for Medicare and Medicaid Services released a press release basically saying, well, this is going to be our wheelhouse, and we're letting you know right now that it's not just going to be limited to nursing homes. We're going to include hospitals, dialysis facilities, ambulatory surgical settings, home health agencies, and other settings, which are TBD, yet to be defined in the upcoming regulations, that are participating in Medicare and Medicaid programs. And that is really important because the existence of that relationship and the acceptance of the funds from the federal government is really what provides the authority to be able to impose this. And that's where that's coming from. We are expecting to see a rule coming out in October. That seems to be what the sort of wise future fortune tellers are saying. And essentially that it's going to be a vaccine mandate. And frankly, quite a number of employers and businesses in this realm are already, in anticipation of this coming, getting ready for it to happen, strongly encouraging their employees to get vaccinated ahead of time. And certainly the president has urged, and CMS has already encouraged, to get moving on this. Start educating your employees that it will be coming, figure out, if you don't already have clinics in place, how you're going to get those in place. Interestingly, within the last few days, the CMS administrator, Ms. Lasser, gave an interview and talked about the fact that they really did put a lot of consideration into this requirement. They thought long and hard about it, and they do recognize that right now the industry is experiencing a massive staffing shortage. But in their mind, they felt, well, there's also staffing shortages that are being caused right now by staff members getting COVID and having to either isolate or quarantine. And they really felt that this was necessary. There's a number of industry groups that are attempting to do their best to lobby and influence the process right now. The American Hospital Association, for example, has given a plan and a list of recommendations. And one of them is to have a significant enough lead time that healthcare providers can actually get this in place before enforcement begins. As a quick reminder, there are a number of states, and this is not the whole country, this is sort of Pennsylvania and who's close by, since Post and Shell, of course, is based primarily in Pennsylvania with some additional offices. There are states with healthcare mandates in place already. The most recent that we've seen was in Philadelphia, with healthcare employers really needing to adopt policies, get their procedures in place, and figure out how they were going to require this of their staff. So just because we don't have anything from the federal government, you may be in one of these states and already have this in place. And just to give you a quick update, because all through COVID, there have been a lot of discussions on, well, what's going to happen? Are employees going to sue? Are unions and industry groups going to sue? So far, at least in the healthcare field, vaccine mandates have been upheld, and they have been mandates that were selectively imposed by the employer, not because the federal or state government was saying they had to, but because the healthcare system made a decision that that is what they believed needed to be done for the safety and health of the employees and the patients. You may remember in June, there was a case in Texas where Houston Methodist Hospital elected to put in a vaccine mandate. It was challenged. I'll be honest, it was a little tough for the employee to really make a case here because they brought their suit before the mandate was in place and were kind of speculating as to how this was going to impact employees. And the judge who upheld the mandate essentially said that, look, when you accept a position and you take a job, you trade off some of your individual liberties to say what you believe in and what you're going to do, and that all employers impose limits on worker behaviors, and a vaccine mandate is just one version of that. More recently, actually just a few days ago, in Kentucky, St. Elizabeth Medical Center also had a mandatory vaccine policy, again, not required by law. And here the employees did try to make some more substantive arguments that the employer wasn't following the ADA and granting accommodations. They weren't complying with religious accommodations. I'm not going to go through them in great detail, but you can see that the statistics show the hospital was taking accommodations very seriously and were granting those that they felt were legitimate. And again, a similar judge decision that this is a condition of employment. It's no different than uniforms or having to get the flu shot, and that when employees come to work, they make a choice to trade off their individual liberties in exchange for a job. So far, they've been upheld with healthcare providers, and that will hopefully continue to be the trend if this is something that you want to do until the federal government says that you have to do it. One quick note, I would just point out that Montana is actually one of the few states that's gone the other way and made it illegal to require vaccines of employees. And out in Montana, the medical association, a couple of medical associations have gotten together and are basically challenging that law on the basis that that is actually a significant danger to the employees and the patients, and that they want that law to be overturned.
So before we move into the employers with 100 or more employees, I just wanted to address one of the questions in the chat from Deb. Would you please define subcontractor again as it applies to the order? And yes, so if you go back to slide 12, we have a slide that indicates who is a federal contractor, and specifically the language in the executive order indicates that it subcontracts solely for the provision of products. It does not apply to subcontract solely for the provision of products. So Angie, I don't know if you want to give any other examples of that, but that is what the executive order makes clear.
Yeah, so the executive order and the guidance that came out actually don't speak that well to one another, but the executive order, it's pretty clear when you read it that it's really based on being on federal lands or being in a service rendering position. And the concept there, I think, is that if contractors are going to be on federal lands where federal employees are going to be exposed, that's what they're focused on. If you are a manufacturing facility and you're, down the line, you're the first, second, third tier, and what you're doing is producing products that are being shipped off and incorporated either in a greater product or in a service, but you're completely isolated, your people aren't going on federal property, and all that's going out from your company is products, the reach is not that far that it gets to you. It's really trying to get to services and interactions between people and either federal property or federal employees.
And I'll address one other question, and then we'll move into the 100 plus. What about first responders, such as police officers? Is there a mandate? At this point, unless state law in Pennsylvania currently does not have a vaccination requirement for first responders or police officers, but if you are a municipality, if you're under, the likelihood is you're not going to have that at this point unless the state puts some requirement in. And there's really some question as to whether the OSHA ETS that is going to be issued is going to apply to municipalities at all, given that generally OSHA does not apply to municipalities. So we'll have to stay tuned for clarity on that. There has not been indication in the original 6-point plan of whether this would apply to municipalities, but at this point, we're leaning towards no, but we'll always have to wait and see once they're ultimately issued. So now let's move into the employers with 100 and more employee category and talk a little bit about what we should be thinking about. So as I've already said a few times, under Biden's 6-point plan, employers with 100 or more are going to have to require employees to be vaccinated or provide proof of weekly negative tests. So I want to be clear, that's different than a vaccinate or be fired requirement. There are some tiers where it's vaccinate or be fired. This is vaccinate or provide weekly tests. There'll be provisions where paid time off has to be provided to get vaccinated or recover from vaccination. There has not been clarity as to what exactly that means. How long will you have to be able to be off if you have side effects? Is it just a day? Is it 2 days? We'll have to wait for the ETS to see. But what we do expect is that within the next 30 to 60 days, we will have an ETS. It's likely the enforcement of that ETS will not begin until December, which would be consistent with the federal contractor compliance deadline. They gave them 75 days for that. So, hopefully we're not going to have to be rushing things through. Obviously, it takes time for people to be vaccinated. Department of Labor has signaled that employers will be able to use existing PTO to meet their obligations. There's questions about whether remote workers who aren't in contact with others may be covered. As we saw in the federal contractor provision there, they are saying if you're a remote worker, you have to be vaxxed. So we'll have to see how that applies to the next ETS. Lots of questions about how do I know if I have 100 employees? Is it going to be company-wide or location-based, similar to the FMLA? What are going to be the procedures to confirm the vaccination status? Is it going to mirror the federal contractor rules and the proofs? Or will we allow people to just verify or acknowledge that they're vaccinated? I'm going to guess that the answer is no on that. And the biggest question that people are having is who's going to pay for these weekly tests? Is it going to be the employer's obligation or is it going to be the employee's obligation? Who's going to be financially responsible? My understanding is currently the rapid tests are anywhere from $10 to $100. There's a shortage. There was just a newspaper article in our local paper. We're based in Lancaster about availability and the difficulty and the shortage. One of the elements of the act is for President Biden to basically use the War Powers Act to ramp up production of these rapid tests, although I've heard a lot of stories about the reliability of those tests. So all of these things will be fleshed out with greater detail. So what's going to happen, and we're getting questions from people saying, do you really think this is going to go in place? And I'll be honest with you, I do think it's going to go in place, but I obviously, and I think we know already that there's going to be a flurry of lawsuits. September 14th, already the Attorney General for Arizona filed a suit to prevent the vaccines, and the argument basically is it's a violation of our constitutional equal protection clause because it's discriminating against U.S. citizens because they're the ones that have to follow this and lawfully employed aliens. So that's one angle. The Republican state attorney generals, 24 of them have indicated that they're going to file suit, and they sent a letter to President Biden opposing the vaccine mandate. And their argument is, COVID is not a work-related hazard under the OSHA Act. And you do not have the authority to issue this vaccination requirement. And on the right-hand column, Angela found this. There was a tweet, again, on this issue of OSHA doing this vax mandate as an emergency workplace safety rule is the ultimate workaround for the federal government to require vaccinations. And the White House chief of staff, I think, probably is regretting the fact that he retweeted that, and maybe there's a question about whether there is authority under the OSHA Act to issue vaccinations in this manner as opposed to some other mechanism. So we anticipate seeing a lawsuit on that issue. We're obviously seeing retail and other industries give feedback. They want a 90-day implementation timeline. One of the technicalities of an ETS, normally when administrative agencies make rules, there's a very prescribed process where they have to issue the rule. There's a large comment period to get everyone's input. These ETSs are not going through a comment period because they're emergency. So they're not really getting perspectives from various industry groups before they're actually in place and enforced. Under the law, an ETS can remain in place for 6 months only, and then it has to be replaced. It's supposed to be replaced by a permanent OSHA standard, which would require them to go through a rulemaking process. But we'll see if that timeline is even followed based on the severity of the COVID pandemic at that point in time.
So what are we looking at in terms of legalities? We do have on the non-healthcare side at least one suit that's been filed. Now, of course, we're mindful that it's a suit that has been filed to a mandate that is an elective mandate that the company wanted to impose as opposed to one that's required under a statute. But probably most of you heard that the airlines have been imposing mandates. I actually think in this case, I'm very interested to see how this turns out, because this is the first case where the employees have really developed arguments that you look at them and you think, yeah, that makes some sense. So some of the arguments that are being raised by the United employees are, one, you're not allowing an alternative for periodic testing, and even the president seems to think that's okay because that was part of his plan. Two, that there's a flawed exemption process for disability and religious exemptions. And when you look at some of the facts that they have alleged, there do appear to be some flaws. There have been some statements made by the CEO that sort of appear to be very chilling in terms of dissuading employees from requesting exemptions. They put a cutoff date on when you could request one by, and if things develop after that date, I guess you don't get one. And what exemptions people were getting were really just that you just can't work and have any benefits. And there's a question of what other mitigating measures, such as masking, have been appropriate. I think one of their big arguments is that, well, if passengers don't have to be vaccinated, employees in other countries that work for United, they have arrangements where pilots can ride on other airlines' planes in the cockpit. If all of those people can bring COVID onto the plane, how does it make sense that, the flight staff need to be vaccinated? So I'll be curious to see how this turns out, because these are different arguments that we've seen in some of the healthcare cases. I think because this case is coming at a later time, and these are certainly better arguments than I think we've seen in some other cases. So this is certainly one to watch. What can we be doing now to prepare for the fact that this is coming? Well, at this point, we have some things we need to look at in terms of our own business. First of all, as Biden announced his plan, it's a choice between a mandatory vaccination or weekly testing. And I think most people are interpreting that as we're going to put in a vaccine mandate. However, with that mandate, we recognize that if an employee agrees to do the weekly testing, they may have an exemption. We don't know yet, but that also, this interpretation also leaves open the possibility that an employer might say, I'm not going to mandate at all. I'm just going to require weekly testing for anyone who's not vaccinated, and I'm just not going to bother with a mandate. Based on what we know so far, that seems like that might be a possibility. We will be finding out from the ETS whether that's the case or not. But what can you be looking at, I think, is practically something that's important. What is your current vaccination rate? Do you know it? Do you have a sense of, if this goes in place, if we're talking about 5% of your workforce versus 55% of your workforce, you're in a different position in your decision-making process. Do we have administrative staff that is going to be able to handle the testing, the weekly testing, and making sure, how are we going to make sure everyone turned in their test? We don't know yet what the cost is going to be or who's going to bear it. Unfortunately, through this entire COVID process, Any chance there's been to shift a cost has been shifted to the employer. With the Families First leave, that was an employer cost. In the healthcare setting, we're seeing most of the costs under the healthcare ETS be put onto the employer. So I'm not going to be terribly surprised if this ends up being an employer cost. And really, we need to be looking at creating our religious and disability accommodation processes, which Teresa is going to talk about in a little more detail. So I will leave that for now. If you have a union workforce, you need to be thinking about this now. Is this a bargainable issue? That may depend on the language in your collective bargaining agreement. Do you have a term in there that allows the employer to adopt reasonable workplace safety rules? Do you have a past practice of implementing safety rules without bargaining or having flu shots in the past? Frankly, what's your relationship with your unions? Is it positive? Do you have a cooperative relationship? Does the union grieve and challenge everything? I haven't listed them all out here because frankly, once I started looking at it, there were too many to list. Unions are all over the place. We have some nursing unions saying, absolutely, you must mandate an employer. If you don't, we view that as a breach of your obligation to provide a safe workplace. We have Teamsters unions and other unions saying, absolutely not, you have no right to do this. And if you do, you have to bargain it. The teachers union actually flip-flopped. The American Federation of Teachers first was totally against it, and now they've changed their tune. If this is bargainable, what might you have to look at? What employees are going to be subject to vaccination? Is it everybody? That might not be bargainable because it might be specified by law. How much time are people going to have to do it? I think the unions are certainly going to care about how much compensation their employees are going to get vaccinated, to be off if they have side effects. And what is their consequence if they fail to get vaccinated? Is it a termination? Is it the weekly testing? Are there other things that can be done? So think about it and assess your relationships now with your union so that when this comes through, it's not the first time you've thought about it or opened the door to communication. I mean, if you have a positive relationship, they know this is happening, and you may want to start having those conversations now so that you're not stuck between a rock and a hard place when the law comes out and suddenly for the first time you're learning, oh, your union is not on board with this.
We have a question in the chat from someone asking questions about 100 active employees in the measurement period that kind of beckons back to the Affordable Care Act analysis we were doing about applicability many years ago. The answer right now is there's no answer. We don't know what the measurement period is. We don't know whether it's going to be whoever has 100 employees as of a designated date, or they're going to do a look back period. We're going to have to wait until we have clarity from the ETS. One quick slide, just because we've been getting a lot of questions from people about workers' comp. We are not workers' comp specialists. However, we have many workers' comp specialists at Post and Shell, and we've actually talked to them about some of these questions. What's happening? I think for the most part, COVID, when it's work-related, is compensable. Some carriers are accepting them depending on the workplaces. Some are not, and they're fighting them to see whether they can show that they're work-related. What about adverse vaccine reactions? What happens when we have an employer-mandated vaccine? Is it going to be a compensable workers' compensation injury? And, the best comparison at this point would be that in 1962 with the typhoid shots. Luckily, that date is actually before my time, which is a pleasure because most things are after my time, that they typically are considered a compensable injury. There may be in some states other than Pennsylvania relief if the mandate is required by law as opposed to a permissive mandate. But really the best answer is that you should talk to your carriers about any types of adverse reaction claims. As somebody said, you required me to get a vax and I have an adverse reaction, serious, contact your carrier, report it, let them handle the claim, decide what they're going to do with it. So now we're going to focus a little bit on anticipating an accommodation program for you who are 100 or over, or those of you who have voluntarily decided to put mandatory vaccinations in place in your workplace. This is very important. You do need to have a vaccine exemption process, or else you're going to have the EEOC knocking at your door telling you that you are violating our EEO laws. And there's really going to be two types. One is a disability-related exemption. Again, we want to make sure that we have a form sequence. If you've worked with Angela and I, you know that we are crazy about forms. We provide forms to our companies because we want you to be able to document your steps. In certain types of cases, sometimes the absence of documentation is worse than the ultimate decision at the end. So we want to make sure that you have a form process for people to request medical exemptions. You're going to have to provide reasonable accommodation unless it creates an undue hardship or poses a direct threat, which all of you have heard before under the ADA. Obviously, the Biden option for weekly testing would provide a basis for an exemption because there is an alternative, and it would be getting weekly tests. Certainly, if you're in one of the mandated workforces such as healthcare, where it's not it's not vax or test, it's vax or be fired, that would be a mitigating factor. Religious exemptions are a little trickier. Most employers are not accustomed to religious exemptions. Sometimes in our neck of the woods, they're more common with our Amish residents on certain key points. But, you know, this is one of these areas you're going to have to bone up on what a religious exemption is. It has to include an accommodation process based on the employee's sincerely held religious beliefs, practices, and observances. If you've heard any of our presentations before, we'll go through some of the religious requests that have come through for religions that no one has ever heard about. It's not just an organized religion. It can be beliefs that are new, uncommon. They can be beliefs that are different than the formal mainstream church or sect. It can be subscribed by a small number of followers. And even if it doesn't make sense to you, that's not what the inquiry is. It's basically whether it's sincerely held religious belief by that particular employee. So again, we're gonna tell you that we want you to make sure that you have a form to go through this. Here are just a few examples of the nuances that exist with a religious belief. So if somebody says vaccines are against my religious belief, that in itself would not be a religious exemption. And why? It's because we haven't gone through the elements and the details of saying it's a sincerely held religious belief. And we can get more information about why it's a sincerely held religious belief. If someone says it's the mandatory vaxes is a act of disbelief in the power of God to heal and protect, well, that probably would be a religious belief. If they said my rabbi told me not to get it, that may be a religious belief. If they say I believe it's going to hurt my body and that I don't know what's going to happen with this in the future, that's not a religious belief. That's just a general medical belief, and that does not in itself necessitate an exemption. We do see certain issues with churches that the mainstream church is saying one thing and various elements are saying other things. Ange and I read an article this morning about a religious exemption that you can get online. I don't know what the going price of that is, but unfortunately, this is something you're all going to be experiencing in the very near and dear future. Key issue is we have to engage in an interactive process that's clear with any type of exemption request. We can ask what the employee's religious beliefs are. Ideally, it would be in a paper format, so they have to write it out instead of verbally. We can't require documentation from a religious leader. Things to look at: have they behaved in a manner inconsistent with stated beliefs? What's the timing of the request? Will it pose an undue hardship for us? Are there other mitigating measures that would address the undue hardship? Putting them in a different area, masking, remote work, isolation, weekly testing. These are all going to be issues that you'll have to grapple with.
Most of you know that throughout COVID, vaccines is just the latest area where we have to be looking at disability questions. We've had a number of them come along the way, and as COVID goes on and changes and we learn more about it, new things are coming up. Within the last couple of weeks, The EEOC and the Federal Department of Health and Human Services have put out guidance on this concept of long COVID or long haul COVID, where somebody experiences COVID, they become infected, they generally are able to get back to work in the sort of standard timeline of 10 days to 2 weeks, but they have these lingering symptoms where for weeks and months afterwards, they are just not themselves. They're tired, they can't concentrate, they can't breathe. I won't go through every one of these symptoms here, but essentially there has been a recognition at the federal government level that this can very well be a disability under the Americans with Disabilities Act. Now, it's not a blanket that it always is, but it's the kind of thing where if it's happening with an employee, if somebody is having performance concerns, if they're coming with you and saying, I need time off because, once a week, I'm just completely wiped out from these symptoms and I believe it's related to COVID. We may need to go through our FMLA process if a doctor is going to say that that's, it's a serious health condition related back to COVID and maybe they need intermittent leave. Or more likely, we may need to go through our ADA process that perhaps they need accommodations in the workplace. It may mean that they need a break every now and then. It may need that they have to have some adjustment, transfer to an open position. But just be aware of it because it's happening enough that we are getting guidance on it that employers do need to recognize it. And we can't just brush it off and say, oh, well, somebody gets headaches every once in a while. We're going to ignore that. If it's tied back to COVID and, they're having long-term symptoms, we may need to go through our disability accommodation process. Remote work, I won't spend a ton of time on this because I think most of you have dealt with it by this point or have had some interaction with it. The main thing that is really coming back around on the remote work is what do we do now with people who they wanted remote work pre-COVID and we denied it. We let them work remotely during COVID. And now that we're all back, they're coming back and saying, well, hey, I did great while I was on remote work during COVID. So you got to grant this for me as an accommodation long-term, even though you wouldn't let me have it the first go round. Not a big surprise here. The EEOC has said that, well, yes, actually how they did during the panicked send everybody home period of remote work is relevant to their renewed request. If they, were able to do it successfully, that may have established that they're able to do it, that it's a reasonable accommodation, that they successfully did a trial period. You also have to look at some other pieces of that, though. Did they actually do a good job while they were out there? I mean, if their productivity was down by 50%, I think that calls into question whether it's a reasonable accommodation. Most of us sent people home with very little notice and very little formality, and large chunks of people's jobs were just put by the wayside when they were working remotely. If you excused duties so that people could work from home, you're not obligated to do that forever. So that may be another angle that you need to look at in terms of granting it as a permanent accommodation. If you took off 30% of somebody's job, you don't have to do that till the end of time just because you did it for COVID. And just a quick update on where are we seeing enforcement. This is actually right now where we're seeing enforcement from the EEOC. Just recently this month, the EEOC filed its first pandemic-related remote work case against ISS Facility Services, and it's exactly the facts that I laid out. Somebody had asked for remote work. They had not gotten it. Then everybody went and worked at home during the pandemic. When people were ordered back, the employee renewed the request. And I mean, you can kind of see where this is going. Request denied. Oh, and guess what? Within 2 weeks, the employee was fired. So this is the classic case where the employer did not communicate that there were performance concerns. And I think this is going to be a hotbed of enforcement. So if you have remote work requests were really, I think, from what we were seeing, people were requesting them more frequently pre-COVID, particularly with mental health concerns. And if you have those employees who come back after the recall to work and ask for it again, you're really going to have to treat those carefully and look long and hard at whether they need to be granted in some form, even if it's just a couple days a week. Okay, COVID leave issues. It's always good for us to have a refresher. I know that you guys have been dealing with leave, and leave has changed a little bit because we've had The Families First Coronavirus Response Act is now expired, so we don't have all of those obligations. I'm going to do a very brief hit on healthcare employee leave. I'm not going to do a huge dive on this because most of you have already probably sat through 10 webinars on the OSHA healthcare ETS, and so I don't want to bore you by repeating things you already know. But just as a quick refresher, there's an ETS in place. The main piece of it that governs leave is the medical removal provisions, where if one of these 5 elements happens or circumstances happen, you are required as an employer to remove the employee from your workplace. They're COVID positive, they're diagnosed, known or suspected, they have certain symptoms, and the last one is a close contact. They come in close contact with a COVID positive person in the workplace at a time when they are not wearing PPE. Important to note, does not apply to close contact at their family barbecue. It's only when they've had close contact working for you or one of the more tangible forms of needing to be out of the workplace, like they've got a positive test result. What's the period of leave? I'm not going to go through every item on here, but the ETS very clearly lays out how long someone needs to be out for all of the various reasons. You can see the reasons listed on the left and then what the leave period is. One thing I think that's important here is the ETS does provide for return guidance based on what the doctor says. In the early days of COVID, some of the doctors seemed to be a little hesitant to give remote work or return to work notes. And it was all, what did the Department of Health say? But now doctors are certainly doing a little better at saying, Susie can come back on this date. And so if you have that, you can rely on it. In all but the positive test, you can always use the testing return to work criteria. And again, I'm not going to go through them in detail, but you'll have the slides and you can look at them. Quick reference to the CDC's guidance, because that really is what's driving return to work in healthcare. You've got your symptom-based and your test-based strategy. Again, all laid out here on the slide. I know you've sat through webinars on it, and I know you have eyeballs that can read. So I'm not going to go through this in painstaking detail. You do, and this is kind of setting the stage for the employers with 100 or more. In the healthcare setting, a lot of financial burden was placed on healthcare employers. When employees are required to be removed under the ETS, there is a payment obligation. There's a wage replacement obligation up to $1,400 a week. If you're a large employer, meaning 500 or more, it's $1,400 a week the whole time they're out, which means if they're out and they go to the ICU and they're out for 6 months, you're paying that. There is a small little bit of relief for smaller employers that they can step down their wage replacement after the first 2 weeks, but it is burdensome. Removal does not depend on where the employee contracted, except for the close contact without PPE. You certainly have some options to let people work remotely or in isolation. And my recommendation here would be, don't assume that just because you're in healthcare and your employee is in a patient caregiving role that you can't consider remote work. You may be able to craft a telework type of position that temporarily works out to have somebody continue to work if they're able to still work and they're not bedridden by COVID. I mean, if you're in a multi-level care facility and you have, a no care level all the way up to a nursing home, you may be able to create a telework position for your, your residents who are mostly independent living to be able to call in with questions rather than pay for someone to be sitting at home. As a reminder, the pay is based on the regular rate and does not include overtime. So even if someone has worked 50 hours a week for the last 3 months or is scheduled to work 50 hours a week, they are not entitled to the overtime in their wage replacement pay. And importantly, you can use or require use of existing paid leave, paid sick leave and PTO, similar to how we substitute paid leave under the FMLA. If people have 3 weeks of PTO, you are perfectly entitled to allow that to be used up or require that to be used up before any other benefits kick in. Now, you're certainly going to have situations where somebody either used all their PTO or they're new and they don't have any yet. But for all of the policies that I have helped prepare at this point, that has been a critical element, that employees will first be required to use accrued PTO before any other wage benefits will kick in. Tracy, you're on mute.
I got it. Thanks. Our final topic is a little bit of a refresher. We're starting to see that as this pandemic lengthens, there is a little more ambiguity and questions about some of these issues. And we just want to refresh you with what the recommended quarantine and isolation periods are. It was a little bit easier when we had a state order that identified the CDC regulations, but we certainly are seeing some inconsistencies in medical notes coming back and how schools are quarantining, and sometimes just confusion about what the periods are that are being recommended. But just to remind you that for a non-healthcare employee, quarantine and isolation is going to be governed by work guidance from a licensed healthcare provider. So a doctor's note saying what the quarantine or isolation period is, state and local requirements that can tell us what we have to follow, or the CDC interim guidance on ending isolation and precautions, which is not easy to follow, but we'll go over it. Remember that COVID infections also trigger FMLA paperwork. It could be a serious health condition. So hospitalization, out 3 days or more, or diagnosis with COVID infection should trigger your FMLA paperwork if you're 50 or over. Pay status while on leave, the voluntary FFCRA or the FFICRA. Remember, we had the mandatory last year. We had a voluntary extension, which just happens to sunset today. So no more tax credits after today, unless we see something come back from our beloved government. People can use existing PTO, vacation, sick. Some people are putting special categories of emergency COVID leave in place. There can be short-term, long-term disability coverage. You do need to check and see if somebody has a COVID infection, whether that would be something that they could collect short or long-term disability under. And most importantly, some people are taking the leave paid unless it's required in the non-healthcare setting. Similar to Angie's previous slide, Angie can flip to the next one. So similar to her recommendation or summary of recommendations from the CDC on the healthcare, this is what the CDC is currently saying about the quarantine and isolation periods. This is their guidance. So remember, quarantine is different from isolation. Quarantine is when we have to separate people who were exposed with someone who had COVID to see if they become sick, whereas isolation is we're separating people who have known cases of COVID. You can read this, but there's 3 tiers for fully vaccinated. It's not required to quarantine unless they have symptoms. They should get tested after 3 to 5 days after exposure and wear masks in public for 14 days until there's a negative test. That's the recommendation by the CDC. If you're not vaxxed, it would be a 10-day quarantine without testing, or a 7-day quarantine after a negative test result, but you have to get the test on day 5 or later. If you previously tested positive for COVID, you're not required to quarantine unless you have symptoms. But in the fully vaxxed, they're recommending masks indoors and in the public for 14 days. In isolation, obviously, that's much more serious. All of the 3 categories are outlined here. What we're seeing to become more complex is not just when the employee has COVID, but when various family members then get COVID and the isolation periods and the quarantine periods tack on one another so that they can be out for around 20 days until the full course of the recommendations of the CDC or the medical professional are followed. So we are right on time. I thought that we have answered almost all of your questions in the chat. If we have not and you have ongoing questions, feel free to reach out to us or any of the members of the employment law team. It has been our pleasure to talk to you. I know we'll be doing another one. Someone from our firm will certainly, if not us, someone else will be giving updates when the ETS is actually issued. There'll be a lot of questions, but HR people, we've done this before. We can get through it. We'll figure it out. and we're here to help you in that process. It's a pleasure seeing everyone this afternoon.